Welcome to the membership meeting of the Cooperative and Condominium Advisory Council. I'm Jeff Hanley, Associate Director of the CCAC and the Building and Realty Institute. On behalf of Albert Annunziata, our Executive Director, Diana Burrill, Chair of the Co-op and Condo Council, Jane Curtis and Angelo Ponzi, Vice Chairs of the Co-op and Condo Council, and Eric Abraham, Chairman of the Building and Realty Institute, our parent organization. Welcome. We have a great program online for this evening, but we do have some quick announcements. As you know, there's always something going on at the BRI. There are always meetings, and we are happy to report the following events are approaching quite rapidly. For members of our Apartment Owners Advisory Council, tomorrow evening, here at the Crown Plaza in White Plains at 5 p.m., a seminar on filing your operations and maintenance cost surveys. The next general membership meeting of the Builders Institute, Building and Realty Institute, is scheduled for Thursday, 6:30 p.m. here at the Crown Plaza. Very, very interesting topic. Challenges facing builders and developers in Westchester and Fairfield counties. Thursday, April 21st, the social event of the season. Our parent organization, the Building and Realty Institute, throughout this year is commemorating its 70th anniversary. On Thursday, April 21st, we will be having the birthday party to end all birthday parties at Glen Island Harbor Club, New Rochelle, 6 p.m. Information is at buildingandrealtyinstitute.org, as well as on your table. There's a nice flyer on your table that Albert Annunziata passed out earlier. And finally, on Thursday, May 12th, the May General Membership Meeting of the BRI will focus on the latest activities of the Westchester County Industrial Development Agency. We are so grateful to our sponsor of this evening's meeting. His name is Darren Johnson. He is a member of our association for the past 3 years and has been very active in many of our programs. His company is Petro Commercial Services. The firm is based in Maspeth. At this time, we will call Darren up. Darren will give a brief overview on his company and the services that his firm offers. I think Darren is over there. Here he is, Darren Johnson.
Thank you, Jeff. Appreciate being able to sponsor tonight's meeting. And just want to reference some of the information that is in the folders that I've placed at the tables. So that way, there's two things I want to address tonight. One, just introduce Petro to anyone who may not be familiar with our company. Petro is the largest division of a public company, Stargas, which is listed on the New York Stock Exchange. And Petro is the largest heating oil company in the country. We're from Massachusetts down to Pennsylvania, and Stargas is from Maine to Georgia. Petro's been in business for over 100 years and providing our customers turnkey energy services and solutions. And the Maspeth office that I am a part of, we focus on New York City and Westchester County. Just to kind of highlight a couple of the things that are in the presentation, the 6 pages. We have 24/7 service that we offer our customers. Our technicians average 20+ years of industry experience. We were a New York City Clean Heat official partner and have been playing a major role in helping our customers comply with the local law 43 in New York City as far as the conversions away from number 6 oil and 4 oil. We do service oil equipment along with gas equipment. We provide the conversions from to dual fuel or to gas. We also do boiler installation replacements if that is necessary as well. And as far as on the fuel oil delivery, we do not employ any truckers or contractors. All of our deliveries are by metered employees of the company. Just to kind of highlight some of our past experience, where we have been able to separate ourselves from our competitors, is that during Hurricane Sandy, and it's another piece of information that is in your folder. We worked 24/7 and housed our employees in hotels in New York City, so that it wasn't an issue of them being able to get into the office or back. We basically held staffing there to be able to make sure that our customers were able to get up and running as quickly as possible. And to highlight that is this flyer from the New York Stock Exchange, which they had published to thank those companies that helped them to get up and running as quickly as possible, which you will see that Petro has mentioned there as one of those companies to help them. And then also, back on after 9/11, we supplied all the diesel for the Ground Zero equipment, and so we have a lot of experience in making sure that our service is there for our customers on a timely fashion. Lastly, just wanted to, after a brief overview of our company, highlight something that we're offering the memberships, here at BRI, and it's just trying to tailor-make some incentives for the members here. And just so you know, the things that we will work with individual members with to be able to make sure that it fits your needs would be on oil pricing discounts from our oil rates, the boiler burner equipment for conversions, installations, upgrades, service agreements, and also on the air conditioning side, service and tune-ups. That is something that everyone might be taking a look at as far as coming into the summer season. That's an area that we can work with you as well. Any questions that you may have, I will be around. Look forward to being part of the BRI, continuing the membership and helping the members in any way that we can. Thank you.
Darren, once again, thanks very much for your support. It's very much appreciated. Okay, time to start the program. We have a great panel, by the way. In hockey, when a forward or a center scores 3 goals, it's a hat trick. This panel, I know, the 3 of them will score the hat trick. They are very well versed in the topic that we are focusing on this evening. Our first speaker is Daniel S. Finger. Daniel, of course, is no stranger to our memberships. He is an attorney with Finger & Finger, a professional corporation. The firm, which is based in White Plains, serves as chief counsel to the Building and Realty Institute and its affiliate groups, as well as our group called Macondo Counsel. Mr. Finger serves as a special counsel to the Apartment Owners Advisory Council of the BRI and the CCAC, as well as other BRI component groups. He also helps in the writing of a column for Impact newspaper, our official publication. He has spoken at many of our association's membership meetings in recent years, so as I mentioned earlier, he is certainly no stranger to all of you. Mr. Finger is involved in the general practice of law. His areas of practice include real estate law, Article 78 proceedings, cooperative and condominium law, and landlord-tenant law. Please welcome our first speaker for this evening, Daniel Finger.
Good evening, everyone. Nice to be here. We're going to talk tonight on enforcing the House rules. And before I get started, two things. One, I would ask just to hold your questions to the end. We're going to all give separate portions of this. We've kind of divided it up, so I have a feeling some of your questions might be answered in the course of the evening. The other thing is, obviously, while I encourage you to ask whatever questions you have, obviously, if you walk out of here and you think of a question, you can certainly pass it on to Jeff. Many of you probably have your own counsels, and you don't have to wait 3 years until another similar presentation comes along to ask a question. I encourage you, whether it's me or whoever your attorney is, if you have a question, you should ask it. I find that whenever I come in here, the minute I walk in, and I obviously recognize a number of you, somebody comes up to me and says, "Oh, I have a question on the topic tonight." You don't have to wait for the presentation to think of your questions. In any event, so I'm going to talk a little bit on, at a more of a macro level on house rules. I think before you can talk about enforcing them, you have to understand the right way of creating house rules and really what a house rule is, and then the mechanics of enforcing it. So, rules and regulations. So the first thing is a house rule. There's a couple, obviously, whether it's a co-op or a condominium, there's the governing documents for the building. In a co-op, it's the proprietary lease and the bylaws. In a condominium, it's the offering plan, the declaration, really declaration and the bylaws. Those give the general authority for the house rules. That is, again, as I'm talking the macro level, those give you the general outline and how, the rules that govern your building, and it determines what a board can and can't do. And the house rules are more specific, and it really is what the board passes in order to regulate the use of the apartments, the common areas, the way people live in the building. The subjects, and I think understanding some of the subjects that are right for house rules helps understand what they are. They have to do with the quality of life, with safety. These things can be sublet and rental policies, move-in and move-out procedures, apartment alterations, pets, noise, smoking. I got a new one tonight. One of the questions that was asked of me as soon as I walked in had to do with that they were advised to make a house rule for drones. Something I never thought of before. Wouldn't have even occurred to me. Drones, like little kind of helicopter things that fly overhead. Apparently, there's an issue, and they were advised by their insurance company that they should, pass a house rule banning them because it could be liability to them if they hit the car, if it hits somebody's car or hits somebody or something. I mean, I think that might be getting a little too sensitive and too specific. But look, if your insurance company tells you to protect yourself that you're not covered, so you need to pass a house rule, then you should probably listen to them. But so there's always going to be topics. I mean, you can get as specific as you want. There are times, obviously, where you can be getting a little too specific. But it always has to do with the quality of life, the enjoyment of the common areas of the apartment, of the building, and the premises for everybody in the community. So generally speaking, that's what the house rules are. And when you're creating rules, you want to be specific. You don't want to be general. This is not a community guide of, great places to go to eat, or it would be great if you didn't use the elevator in, late hours, or it'd be really nice if you didn't make noise after 11. That's not really a rule, that's a guideline, and guidelines aren't going to do it. So if you want to have somebody not do something, you need to say, no noise after 11, or whatever it is, or no smoking, or no pets, or whatever the rule is, whatever you're trying to accomplish, you need to be specific, you need to be definitive, and the rule needs to be enforceable, and the board needs to be willing to enforce it. If the board's not willing to enforce it, then there's no reason to have it there. If there are a lot of times where you have rules that are on the books that you haven't been enforcing, whatever, you get some turnover in the board, and a new board comes along and wants to enforce it, that's fine, but you probably should tell people if there's something going on that you haven't been enforcing and now you're going to be enforcing it. You should probably let people know that. I mean, it's, in a technical sense, yes, something's on the books, but you also have to be sensitive to the community that you live in, the community as a whole. This I just stuck in there for Albert's benefit.
Oh, my stars.
But anyway, they should generally be in a format that people can read. If you update them, you should give them to everybody. You know, a great time to do that is at the annual meeting, you know, assuming that you get a quorum and you have people come in mass, which I know everybody has, every unit owner and shareholder come to all their annual meetings. But it's always a great place because, you know, there are at least some people come and you can have them sign in and give them to them. It's an easy way to distribute it. But especially when you make changes, you need to distribute it, you need to let them know, and that's a good way to do it. A lot of times, original rules and regulations for these buildings were created, you know, when the building was first formed, and they get out of date. And there are a lot of people that come to us, there's a lot of boards that come to us and they want help revising them, and there's nothing wrong with that, and there's nothing wrong with making it in a more readable and usable format. Obviously, it's helpful if if you utilize the services of your attorney. They probably have some that they can give you for guidance where other buildings have done it. No reason to reinvent the wheel. So that it's something that's out there. But again, when you do that, obviously you have to distribute it to everybody, and you don't have to stay with the same arcane format that was done 30, 40 years ago. You can make it a more user-friendly format, but still should be, again, specific and definitive. Now, getting really more to the meat of the topic for tonight, enforcement. You should enforce the rules uniformly. You can't discriminate, and this is something that Marc Fang will talk to a little more later, but you can't discriminate against people. We've had other seminars on discrimination. Don't do it. You have to, you can apply a rule. If you have a rule, you can apply it. You have to apply it to everybody, fairly, evenly, or don't do it at all. Again, as I said before, don't have rules that you can't or don't want to enforce. If you're not going to enforce it, you're not going to, then don't have it. As I said, I've covered some of this. Let the residents know about rule changes and enforcement changes. Now, this harkens back a little bit to what I mentioned earlier about that there's always things that I didn't think of. There are unwritten rules, use common sense. People shouldn't be throwing things off their balconies. I don't really think you necessarily need a rule for that. Maybe you do in some places if it's a recurring problem, but one would hope. But there's, you don't have to get hyper specific where every possible scenario in the world. I mean, like I said, there's some things that should be common sense. There's usually, most places have a rule that talks about nuisance and noise and smells. I mean, that can cover a broad range of things. So, smells could be anything from smelling smoke from another apartment to, somebody's cooking and their cooking happens to be making really bad smells. I mean, it can be broad, but, so you can keep that in mind. You can't, like I said, you can't cover everything. You should try. If you're having a problem, if you're getting complaints about some conduct and you want to make it clear, then yeah, pass a rule. And you do have to look to the governing documents to make sure that it's something that you can do. But if it's something you want to do and the residents are in favor of whatever the rule is, no pets, no smoking, anything like that, then there's procedures for passing the rule and you should do it. The ramifications, now this is enforcement, and there's really two main ways that you can enforce a rule. One is you can try fining it, and whether you can legally fine is a subject of debate. A lot of places you can't. Places do it anyway, and it's an issue. Condominiums, a lot of times you can. But again, it depends on the bylaws and declaration for condominium. It depends on the lease and the bylaws for a co-op. Most leases in co-ops, at least originally, didn't have any authority to fine. So unless you amend your lease or something like that, it can be difficult. Which is not to say don't try, because if it corrects the action, and if it corrects the violation, then terrific, you've accomplished your goal. But if it doesn't, then you have to then you have to take it to the next step. As I said, you got to look, if you're trying to fine, you have to look for the legal authority. You don't want to do anything, if you do have the authority, you also have to consider what a court is going to enforce, and you don't want to do something that is going to be so far out of the guidelines of what people think is reasonable, a $1,000 late fee, for example. It's just, you got to keep that in mind. The board should approve the fines. It shouldn't just be the managing agent just, doing it. It should be something that the board's approved. And I have don't repeat. By that, what I mean is, if you have somebody if you have a violation, and assuming you have the authority to fine, and you fine the person, and they don't pay, either they don't pay, or they pay and the action doesn't get corrected, they just do it again. There's no point in continually fining people. If even with with late fees and those type of things, if the action's not being corrected, then you need to go to the next step, which is unfortunately usually go to court. It doesn't help if somebody, if you have if there's other, and then, all right, next step. So certain situations also, are in this same category, like pet situations. Don't bother fining for pet situations. If you have a no pet policy and you find out that somebody has a pet, you need to start the court action right away. You have 90 days to get in court, and Stephen will touch on that a little more, but there's a very strict time limit and there's very strict rules about that. So if you start fining and you wait to see if they're going to pay the fine, then by the time you go to your attorney and say, this person has a pet and, we fined them twice, but they didn't pay it, and, we found out 4 months ago, well, now it's too late. Now you're stuck with the pet. So you got to be careful about that. Hoarders I put up there because a lot of times that's something that, a $50 fine, either they're not going to pay it, or they're going to pay it and they're not going to care, and they're just going to keep their junk there and they're not going to clean up. It's not something that is typically, at least in my experience, going to cure the violation of the conduct. So it should be something that's going to cure the conduct, and especially in that situation, usually those require more detailed action, more in-depth action, some kind of court supervision, a fine, and that kind of action is not going to do it. The frequent or repeat offenders, and then also, there's no point in putting fines on fines, or late fees on late fees, that kind of thing. I mean, it's something the courts are not going to look kindly on it. So if you do get to court and they see that a person owes $1,000 and $500 is maintenance or common charges and $500 of it is late fees, they're not going to award it. You're going to get the judgment for the common charges, and they're going to make you withdraw the late fees. You're not going to get an award for that anyway. So again, there's no point in giving somebody a late charge for 6 months. If somebody doesn't pay their common charges, their maintenance, you should have a procedure in place, whether it's, after 2 months, after 3 months, send it to your attorney to start proceedings to get the money. Don't wait beyond that. It's just going to delay things. It's going to take longer, and it makes a bad situation worse. Now, the court actions differ depending on whether you're a co-op or a condominium. A co-op, the court action is much easier. It's a summary proceeding. It's quicker. I shouldn't necessarily say easier, but it's quicker in any event. It's as I said, it's a summary proceeding, so you're usually in court in a matter of weeks or a month or so, a month or two at the most. And once you're in court, it's a much quicker process. In condominiums, any court actions have to be Supreme Court actions. So that you have to, like any Supreme Court action, you have to do a summons and complaint. You file it, you serve it on them, you give them a month to answer. They answer. If there's no agreement or nothing happens, you can try to make a motion. You probably won't win if they're denying the charges. You then have to go through discovery. I mean, those actions can take a year. They can take more. So they're much longer. It's just one of the unfortunate differences where the condominiums suffer a little bit because of when you're going after somebody. Now, certain violations come to the board's attention either between residents or because a resident makes a complaint. So I just wanted to touch on this for a second, which is things that need more due process, where it's not just, you saw somebody with a pet, or you saw something that becomes complaint. Usually this is like noise complaints, or if it's a no smoking building, smoking complaints, or smells. It's important that if somebody's making a complaint, that you get a written complaint from them for the file. This doesn't mean that you have to show the complaint to the alleged offender, but you need it in your file because you need, one, you need to know who it is that's complaining. You need the document in the file. If you do end up into court, they have to understand that then they will be required to come and testify, whether it's a summary proceeding or a Supreme Court action. So you need the complaint in the file. You can send a letter to the offender, and if that, and just inform them of the complaint. Try to get the action corrected that way. If it's something simple, you can, and then do an investigation, and then the next step would be court. I'm going to touch more on investigation. For an investigation, there are certain procedures because of this need for additional due process. If it's one resident saying one thing, he said, she said type of situation, you need to invite the alleged offending shareholder, unit owner to a meeting. If they want to bring their attorney, that's fine. You present the issues that are being alleged, the complaints. You listen to any defenses they have, and then the board votes. And either the board, if the board's done that, and they don't have to vote right there. They can, you wouldn't vote right there. You would not vote in front of them. But you listen to them, you then excuse them, and then you discuss it. You've done your investigation. You can listen to if you want. You can listen to additional people. You have the letters, but you can also listen to people other people come in, and discuss things with you. And then once the board's done its investigation, they feel confident that they have as good an understanding of what happened, and as they can, then they can vote on whether or not they either want to fine or whether or not they want to go to the next step of court, depending on the situation. And then usually that they will be covered if they've done all that. Now, I recap. Again, you have to be able to enforce your rules and regulations, investigate properly, document everything, and if you have any questions, consult your legal counsel. Don't wait. If you have any questions about anything that's going on, of any violations, definitely consult your attorney sooner rather than later. It really helps us. That's it.
Thank you, Daniel, another great job. Our next speaker is Steve Lasser. I met Steve Lasser 2 years ago during the BRI's outing to Yankee Stadium between the Yankees and the Mets. The Mets absolutely crushed my Yankees that evening. Steve offered me some great counseling throughout the whole night. As most of you know, I'm a diehard Yankee fan, and that was a nightmarish scenario for me, but Steve did a great job of getting me through that night. Stephen Lasser is a managing partner of the Lasser Law Group, which is based in Manhattan. He has focused his practice on real estate as both a transactional attorney and a litigator for more than a decade. He acts as legal counsel to developers, lenders, landlords, commercial tenants, homeowner associations, co-ops, and condos. Steve handles complex real estate acquisitions and finance matters, as well as drafting and negotiating commercial leases, construction contracts, and vendor agreements for his clients. He has also successfully litigated numerous lawsuits covering a wide spectrum of real estate-related issues, including construction litigation, shareholder disputes, commercial landlord-tenant actions, and insurance coverage disputes. He frequently lectures and writes articles related to his real estate law practice. Prior to forming the Lasser Law Group, Steve was a partner at 2 prominent East Coast law firms. Please welcome Steve Lasser.
Good evening, everyone. I'm going to try to limit this to 15 minutes. That's the allocated time, so I'm going to press start right now. We'll see how it goes. This is my first time.
We'll keep you on.
This is my first time coming to a BRI event that wasn't a social event, and I have to say, I'm amazed by the turnout. I mean, it's really fantastic, and I serve on my co-ops board, and I applaud all the volunteer board members that are here this evening. It's nice for you to come out and really, it's amazing. And I'm amazed by the facility and just the whole way that BRI runs their program. I speak at for some other organizations I lecture frequently, and I'm really impressed. I'll keep it very short. My introduction about myself. My firm represents approximately 90 co-ops and condos in the city, Westchester and the Hudson Valley. I'd say between those 90, approximately 60 of them are in the city, and approximately 30 are in Westchester and the Hudson Valley. There are 4 attorneys in my firm. By the way, Jeff, that was the longest introduction I've ever gotten. Thank you. He basically read my website page, so you guys know a lot more about me than most people do when I come into a speaking engagement, and I think it sounds a little more fancy than I really am. But anyway, thanks, Jeff. One other personal note: I'm getting married in May for the first time, and I think I'm going to be moving to Westchester. I currently live in Manhattan, and I think my fiance and wife-to-be wants to be here, so hopefully I'll see more of you in the future. So I'm just curious, by way of show of hands, how many people, I want to find out sort of the demographic here, whether it's co-ops or condos. So how many co-op board members, roughly? Okay, that's a lot. And condos? Okay, got a few of both. So Dan and I spoke briefly yesterday, the day before, about the topics we were going to cover, and it was a pretty informal conversation. I'm going to try to not repeat a lot of the stuff he said. I didn't know he was going to have a fancy PowerPoint presentation, or I might have been one myself, so I'm going to try to give you sort of the bullet points of what I'm going to cover, so you can try to follow along and get a sense of where I'm going with everything. Essentially, I'm going to talk, without trying to repeat what Dan had said, about the enforcement of house rules, right? That's why we're here. Some of the challenges, and then specifically, I want to get into some of the nitty-gritty about co-ops and condos with particular governing documents. Now that having been said, I'm going to talk about what I typically see in a proprietary lease, or what I typically see in a condo's bylaws. But you have to keep in mind that the law is constantly changing, and no two governing documents are alike. And I've seen a lot of weird ones out there. So sometimes you have the boilerplate one, sometimes you have the boilerplate plus, sometimes you have the boilerplate plus 2. So I mean, you can have all kinds of weird variations. So you really need to look at your specific governing documents, and also keep abreast of the case law, because the case law is really changing all the time. So what might be true today might not be true tomorrow. That having been said, some of the key things which Dan touched on is that you have to make sure that everything is enacted properly. So that would mean you have to have a board meeting. I would recommend that you take minutes to document it. You have to have a majority, or a quorum, present at the board meeting. You have to make sure that your house rules comply with your governing documents. I see a lot of rules that don't comply with the governing documents. So you really need to read them and make sure, have your attorney read them, make sure that what you're doing doesn't contravene what your governing documents say, because if it does, it's not going to be enforceable. Dan mentioned that in a co-op you can evict someone, as well as fining them if there's authority in your governing documents. And in a condo, your rights are more limited, because you can only fine them, or you can commence a Supreme Court action against them for an injunction. But those are sort of costly, and you don't have that remedy of evicting someone. One thing that I've done with some success, it's sort of like a guerrilla tactic, is in a co-op, I'm sure you're probably aware that when someone purchases, they sign an Aztec recognition agreement. If you're on board, you know you get the recognition agreement. Basically that says if someone's involved in their maintenance, you have to notify their lender. And with some success, I've had instances where the proprietary lease says that a fine or late fees would be considered additional maintenance or rent under the proprietary lease, and we've sent the notice to the lender, and the lender's paid it. Now, doesn't happen all the time. We've also seen instances where the shareholder then files an order of show cause in the Supreme Court to challenge it and creates a bigger mess. But in which case you could just waive the fines or late fees at that point in time. So that's sort of a more subtle thing that you could consider in a co-op if there is a fine that someone isn't paying. So invariably, right, if you end up in housing court or you just try to work something out, the person pays their maintenance and they don't agree to pay the late fees or the fines or whatever it is, the ancillary charges that they don't agree with. So with respect to the topics I wanted to cover, one of them was use restrictions, and that ties in with sublets. And then a couple other ones were noise, which Dan spoke about, smoking, which I think you had a large presentation here a short while ago, so I don't want to delve into that too much. Pets, we have someone here. Our other panel member is going to speak about that. That's his area of expertise. He's going to speak with respect to pets and some parking issues that come up with ADA compliance. So I think you'll enjoy that, and I'm not going to talk too much about those two topics. So use restrictions. In the condominium, you own your unit in fee simple, which means you're the owner. It's analogous to owning a single family house. The only real restriction with respect to the use of a condominium unit is that you have to use it for a residential purpose or a permitted home occupancy. And you can't, it's actually interesting, there's there's a new state law called the Airbnb law. I don't know what the actual real name of it is, but maybe you're familiar with that. I don't know if anyone has a problem here with short-term sublets, but it's interesting because in a condominium, it doesn't really specify, it just says it has to be used for residential use. So, and I'm sort of getting ahead from use to subletting, but it's interesting because what if you're living in your unit but you're renting out a room? Is that considered a sublet? And I would take the position, yes, that it is, but on the flip side, if that person's not causing a problem, it's not like an Airbnb situation where the person, new people are coming in and out every day, and it's helping the person pay their common charges, why would you want to stop that? So I think in a condominium, although it would be illegal to have a short-term sublet, if it's a longer-term sublet, it's basically like a roommate, I don't see any need to stop that, which sort of leads me to co-ops. In a co-op, the standard, or a lot of leases, and actually I looked at a couple today, some of them just say you have to use your apartment for residential use. The more typical one I see, it says that the apartment will be used by the lessee and that's the key word is and, lessee's spouse, their children, grandchildren, parents, grandparents, brothers, sisters, blah, blah, blah. So the point there is, if it says and, my understanding of the case law, unless it's changed recently, is that if it says and, the shareholder has to be there, okay? Some leases just enumerate the apartment can be used by the lessee's spouse, and then it enumerates all the people. So in that case, my understanding of the case law is that the shareholder doesn't actually have to live there, and it could just be their spouse, their children, etc. It's very fact specific, so you really need to look at what your lease says before you sort of initiate an illegal sublet or think that you have an illegal sublet case. Also, another interesting wrinkle is with a co-op, there's a real property law that applies to, it's called the roommate law. And basically, for each adult member that's on a proprietary lease, they're entitled to have a roommate. And for each adult member on the lease, they're also allowed to have their children there. So you can have a situation where someone has a roommate, they're not on the lease, and their children are residing there. And if you were to try to prohibit that or say it was an illegal sublet, you would come into conflict with the roommate law. So that's just sort of something to keep in mind. Like I said, I'm trying to give you guys some nuggets to take away here instead of just speaking in generalities. And then with respect to the Airbnb issue, there's a new state law in New York that prohibits short-term sublets for less than 30 days or rental agreements. So, some buildings, people use their unit as like a hotel, and that's illegal. To get it, the local municipality to enforce that is the easiest thing. They're really going after people that are sort of renting blocks of rooms and sort of using it like a hotel and cutting into the hotel business. But it would certainly be a basis to evict someone in a co-op and to fine them, or you might have a way to get them out of the condo as well, if you sued them in Supreme Court. The other issue is that usually you're allowed to have a permitted home occupancy, and you'd have to check the local laws on that, but they're not going to let you run a dry cleaner out of your office, but other things might be permitted. One that I've encountered on several occasions is a daycare center, and the boards are adamant, we cannot allow the daycare center here. It's a liability issue. There's little kids running across the parking lot, and it turns out that there's a state law, social services law, that says that there's an overriding social need for daycare centers, and that would actually trump your bylaws. I mean, there's case law on the issue, so it's kind of interesting that that even if you're governing, even if it's not a permitted home occupancy, even if your bylaws say that you're not allowed to do it, doesn't matter, you can have a daycare center. But recently, just last month, there was a case where someone purchased a unit, they didn't put on their application that they were planning to use it as a daycare center. I didn't really read the case that closely, but basically what the court said was there's an issue of fact of whether or not this person committed a fraud, because essentially they bought the place to use it as a daycare center, and this was a condo case. The board sued them and said, we would have exercised our right of first refusal had you known and been honest in your application. So there might be a way around it, but if someone moves in and they open up a daycare center, you're probably out of luck. That was an interesting story. With respect to sublets, let me see how I'm doing on time here. I'm doing it right, about 5 minutes. Sublets. So in a condo, if you're familiar with a condo, you have a right of first refusal, which means that if someone wants to rent their unit, the board can rent it out on the same terms and conditions as the person who wants to rent it out. I can tell you, I've been doing this about 15 years. I've never seen a board exercise its right of first refusal with respect to a lease, in a sublease, or it's actually a lease. In a co-op, the board usually has some kind of authority, unless you have really unusual bylaws, to reject a sublet. And the language, I have a lease here, I'm not going to look it up, I'm just going to paraphrase it, but usually it's subject to the board's approval. Sometimes it says not to be reasonably held. Usually it's just subject to the board's approval. So if the board doesn't want you to sublet, basically you're not going to be able to. Of course, you can't apply the rules in a discriminatory fashion. That's illegal to do. The other sort of thing that comes up all the time for me, is that in condos, they want to impose a sublet fee, and it comes up a lot in co-ops as well. So in a condo, if your governing documents don't really specify a fee, you could certainly charge like a processing fee. The managing agent can charge a processing fee, but you're sort of getting into a gray area if you want to charge a fee for the privilege of subletting if it's not in your governing documents. Now, that having been said, I think Daniel alluded to this, is that a lot of times boards do things that they're not really legally capable of doing, or that they shouldn't be doing. Obviously, with something like discrimination, you don't want to do that, right? There's no social good in that. But if, I guess I could say that as long as I know that a board is doing something, and I'll say, listen, you can play a little bit fast and loose. Like, hey, if it's good for the building and no one's challenging it, then okay. If you're not doing something that's really illegal and you're making some extra money, or you're cutting down the sublets and you think it's bad for the building. I don't know if there's any realtors here that are probably like shooting daggers at me for saying that, but that's just the reality. If it's good for the building, and that's what the board thinks, then that might be the building's policy, and then they might get voted out by a block of realtors who work in the building. You never know, or they might file a lawsuit and say that the policy is illegal. Let's see. With co-ops, it was interesting. I was researching a little for this meeting. Is that if your bylaws say, or excuse me, your lease says that it's subject to whatever conditions the board imposes, then you can, the case law says that you can actually charge a fee if it's sort of the board, whatever the board imposes. There's no sort of carve-out language. However, if there's a paragraph that follows that says that the board can recover its fees in connection and its attorney's fees for sort of processing. There's a separate paragraph. The case law says, well, if it says that, then they've already made a decision in the bylaws, the lease, with respect to what you're allowed to collect, in which case a sublet fee would probably not fly if it was challenged in court, which there are a few court cases. Interestingly, they date back to like the 90s, so I guess the board's lost those fights and no one's been brave enough to take that cause up again. But so if there is language that talks about a fee in a co-op, you really can't charge a sublet fee unless you were to amend your lease. And I'm sure everyone in the room knows that amending your lease or in a condo, amending your bylaws, getting a 66 2/3 majority to do that is not an easy task to accomplish. If you do want to do that, I would recommend you get the word out early and often try to get people's proxies. And that's really the only way I've ever seen it. You very rarely see a supermajority at a meeting in person. You really have to get the word out and collect proxies way in advance to try to make that happen if you want to amend your bylaws. Because that's what you have to do, sort of with anything with respect to finance. If you want to make a change, if there is an authority already existing about a fine, about a fee, unless it's some kind of administrative fee, if someone challenges it, you're not going to win if you just put it in the bylaw, if you just put it in your house rules. It really needs to come from the lease or from the bylaws. That's where the authority needs to come from. So we talked about sublets, we talked about Airbnb, I talked about daycare centers. So the next topic I have here, the next topics, I'll just list them all, I'll rattle them off. There was noise, smoking, pets, and parking. With respect to, I'm over, so I'll be quick. Noise, one thing I would say is that these are probably the more interesting stories I encountered. Oh, I'm getting the hook here. So with respect to noise, if you have a carpet rule, enforce it uniformly. If I'd recommend mediation. I feel like there's a person that's hard of hearing downstairs. They move out, and then you have like the perfect storm. Someone moves in upstairs and the kids roller skate in their apartment. But if you could just get them in the same room and say, listen, I'm home during such and such hours, and that's when your kids are roller skating, you might resolve the issue. Otherwise, you're going to go round and round and never get anywhere. And I don't think fines are going to accomplish anything. I'm not going to talk about smoking because you just had that. I think I'm going to leave pets to my colleagues. Parking, just say that if you have deeded parking in a condo, you can't really get the person out of their parking spot. It's hard to. In a co-op, I think it's easier, or if in a condominium, if it's a common area, if someone is violating the rules, if someone's not paying, that's a great way to get their attention. If you tow that car, I guarantee you're going to get their attention. So I think that's a great way to deal with problematic unit owners or shareholders. I already told you need to follow your procedure, put things in the minutes. I'll just say one thing about interest. If you're charging interest, it has to be less than 25% per annum. If you keep jacking interest on someone's account, if you get into court, it's not going to be enforceable. Last thing I'll say, I'll just wrap up with, if you have quality of life issues, I think mediation goes a long way. I know I have some board members here, and they might question whether or not mediation has been a huge success, but I can tell you that once you start litigating and you start getting legal bills, you'll say, you know what, mediation is a good thing. Even if you make a little bit of progress, it's better than paying an attorney and going to court and living with the drama. And then just the last thing I'll just say is, if you have a small problem, try to nip it in the bud. If you let things drag on, you let the fines accumulate, that's not a good way to sort of keep a harmonious community. I think if you try to get people in the same room and try to work things out and sort of nip things in the bud, you'll have much better results. Thank you.
Thank you, Stephen. And congratulations on your impending marriage. There's an old Neapolitan phrase of well wishes and congratulations, and I like to use it often. It's mazel tov. Stephen mentioned the wisdom of arbitration and mediation in maybe most, if not all, circumstances. And just to remind this audience, is that the BRI launched an arbitration mediation alternative dispute resolution service a couple of years ago, and I think we've only had 2 or 3 cases through our members where our members sought a resolution other than a legal one. So that was a good point. I appreciate you mentioning that, because I wanted to remind our members here that we do have that service available through the BRI. Our next speaker, our last speaker, is Marc Fang. He's an attorney and the executive director of the Westchester County Human Rights Commission. I guess he may also be talking about pets, I don't know, but we'll leave that up to him. And he's held that position since May of 2012. As many of you know, since he's no stranger to this association, he's spoken many times before to us. The Human Rights Commission works to eliminate discrimination and promote equality by advocacy, educational programs, and of course, when necessary, through legal measures. Mr. Fang, being an attorney, also has a vast experience as a litigator and a legal advocate, including work in the Army Reserves, which is quite close to my heart, with my two sons, as an equal opportunity officer, a long-time practicing attorney in our region. Marc has served as Assistant Attorney General in the Criminal Division of the New York State AG's office. He has also served as Assistant District Attorney in the Westchester County DA's office, and of course has spoken to many other groups in his capacity as Human Rights Commissioner before the BRI and other service organizations. So please welcome, certainly no stranger to this group, Marc Fang.
Okay, so thank you for having me. I've been here before the CCAC a couple times over the years. I've been on the job since May 2012, so I know a little bit more about this stuff at this point. I'm the Executive Director of the Westchester County Human Rights Commission, which includes the Fair Housing Board, which enforces the county's fair housing law, which came into effect, adopted by the County Board of Legislators and the County Executive back in 2008, 2009. Human Rights Commission does other stuff, employment law, public accommodation law. That became into effect in 2000. I'm going to go through a few things, a few interesting topics, might jump around a little bit. I handed out some articles that over the last couple of years, I had published in the New York Law Journal based on topics that, sitting in my day-to-day job at the Human Rights Commission, that I came across that, and then I did some research with the, in the case law and all that, the New York law on fair housing, and then I developed these articles, and I'll just talk about them a little bit. They're not side issues, they're actually important parts of what I'm trying to tell you today. The first one is with the picture of me, sorry for the pictures, but the picture of me by myself is about a term called interactive process. Okay, this is an important term. If you're a board member, the chairman of the board, if you're a managing agent. So what I had seen on the job, I've been on the job for about 4 years now. What I had seen on the job in employment cases, fair housing cases, I had seen a lot of times someone's disabled, okay? They have to take a couple days off from work or something like that, or they need some kind of accommodation. Or in housing, they need some kind of accommodation, maybe a walk-in shower or automatic door, something like that. And what I had seen is these cases come in, the person comes in our door, they email us or they contact us, they come to our office, they make a complaint, and the next thing I know, in the housing context, they just never hear from the board, never hear from the managing agent. They have all these emails, I never got a reply. In the employment context, I never heard from HR, Human Resources. I said I needed a stand-up desk or something like that, or different computer screen. They never got back to me. Or I took a couple days off from work, and I got back and they fired me. They replaced me. So I just thought that if they had just talked it out a little bit, they might have worked this out. And this comes to, you came with our two great lawyers here, this comes out. Use a little common sense, communicate, try and nip it in the bud. as Steve said, those are all great. It's all great advice. And so the article, what the article says is that first article, in employment, it's a requirement, okay, for reasonable accommodation. If a person makes a request for a reasonable accommodation on your job, it's a requirement under the law. There's a recent case called Jacobson, New York State Court of Appeals, which you have to engage in a dialogue with your employee about their request for reasonable accommodation. Not that clear in the fair housing context, so not that clear in the co-op condo context. If one of your tenants, one of your residents asks for a request for a reasonable accommodation, whatever it is, can't come up with an example now, an illustration right now.
A ramp.
Okay, a ramp like that. Automatic door, parking spot, okay? If a lot of times we'll see that, they just get blown off. 6 months, 8 months, we'll get back to you, that kind of thing. That's a problem for you, okay, for the Fair Housing Board member. Because, here's why, here's how I get there. In New York law, and under the federal law, and you'll see it in the article, they don't require it, unlike in employment. They don't actually require that. But in the HUD law, okay, because HUD has these cases, if you go on their website, pointing to nothing, if you go on their website, HUD, they have these cases because they have this whole apparatus of enforcement, just like it mirrors like the EEOC or my agency or the state agency. So they have all these cases. You have to look at that. You have to look at it from my agency. You know why? Because we take money from HUD, okay? And we have a grant from HUD. So from my perspective as a lawyer, those decisions are relevant. They are more than relevant. They're case law for me on the cases. And so we just had a case actually in Scarsdale on an emotional support animal case, okay? I won't tell you which road, but But so this particular building had a no pet policy, and so the first hurdle, and I'll go through it in the slides if we get there, the first hurdle is we're going to take in the case, so the person's going to make a complaint, and then we're going to send you, the board members and the managing agent and your lawyers, we're going to send you the complaint, and then you're going to reply to us. I'll show you in the slides if we get there. But so what happens is at that point, then we'll do an investigation, but we're just looking for probable cause. We're not looking for the right, necessarily guilty, not guilty. We're looking for, does that person meet the threshold of probable cause? So in this particular case, we found there was probable cause that the building rejected their request to keep the emotional support dog, and that was a violation of our fair housing law. That they rejected this person's request for a reasonable accommodation, and then that rose to the level of a violation of our fair housing law against the disability discrimination. So, but that's just probable cause. We'll see what happens going, as the process goes. But we made that decision. And what I looked at to make that decision was I looked at HUD case law, which says that, and I can give you the decision if you want it. I can email it to you. Which says that the person needs the co-op board. You need to engage in an interactive process with the tenant who requests a reasonable accommodation. This is in the HUD case law, and I explained why that's applicable to my decision here in Westchester County, because we take HUD funds, and therefore HUD laws and HUD rules are applicable to our decisions. I can show you the decision. I wish I brought it, but I can show you it. And that case will go to a hearing. I may end up being slapped down or something as it goes through the court process. But from what presented itself, that's the decision we made to probable cause. So let me go through some of these things. I'll go through just some of our processes. I really like what my two presenters before me said. They really, what they told you, that you need to look out for, and what, what kind of things you need to do proactively. It's almost like we got together, which we didn't, about the cases I see. Because all these things come up, the dogs, the parking spaces, all these things, the ramps, and we don't know how, we don't know how to make heads or tails of it. The person comes in, and so we're going to look for every sign of credibility, although we're not going to make the credibility decision. We're going to look and see what that person, if that person's, if their story holds up. We're going to look at that, and then we're going to look at your side of the story. So what Steve said, nip it in the butt. As far as my agency is concerned, I don't know how the other agencies react, or if, if the next person that comes in and takes my place, if that's the way they're going to look at it. But that's compelling to us. If you have like Steve or Dan or Carl come in at the get-go and get your side of the story, your co-op side of the story out in front, and it's not just, you're blowing smoke, that's going to be compelling to us. Because we don't know what to believe. We're going to go out there and we're going to investigate and we're going to interview you, but I think just like if you were, if you were investigated and interviewed by the FBI, who's been investigated? Anybody? No, I'm joking. I always do that. Just like that, you want to get out in front and get your side of the story. We're just bureaucrats. We're just civil servants. So let's see. We don't really know what to believe. Okay. So one of my first missions of this place was I really wanted it to be fair, open, and an expeditious forum. The Fair Housing Board, the Human Rights Commission, has historically in Westchester been well-run, and there's a lot of good historical experience to draw on. It's a good institution that we have set up so far, and that's what I landed into. Okay, now I recognize that when you look at your rules and all those things, there's a lot of categories you need to think about. Some of the very important ones are that we see in the housing context are not so much this. Although the Fair Housing Act, the Federal Fair Housing Act, is really, when it was founded in enacted in 1968. And if you look back at, there's a big decision. Do you know the decision, Texas Housing Development, Department of Housing versus Inclusive Communities? You've heard of that? That's like a seminal case, really big case. It's relevant to you because if you ever get into federal court or even state court on the Fair Housing Act, I think these guys will tell you, that law is powerful toward the tenant, toward the plaintiff. But anyway, that was the original. But what we see now is really a lot of this familial status, which these fellows talked about. Occupancy restrictions. You need to look at your rules related to that. Okay, it's a little bit complicated. Disability, of course. That's what the reasonable accommodation, reasonable modification request. I'm going to tell you a little bit about what I think you should look at for that, a good resource for that. I said it at a previous meeting. And then this, and this is a new law in Westchester, source of income, meaning if I have Section 8 or something else, veterans, okay, I'm a veteran. If I have veteran benefit for housing, and you say, no, we don't take that, I don't want to get, bogged down in the veterans, VA, all that bureaucracy, so, appreciate what you did, but sorry, no housing here. That would be against the Westchester law. But, and you have your organization to thank, because I saw this on your website, it doesn't apply to co-op and condo right now. So I can tell you that's a big difference between your regular apartment building and co-op and condo. It's an exception to the law. okay? I don't make any comment about it, but your organization really saved you a lot of things, a lot of prospective legal fees, a lot of cases possibly. We're seeing a lot of cases in that area. That's what I'm telling you. And so sometimes we see people who come, they say, well, I checked this place, whatever the address is, and they said no, no Section 8 or no veterans or no whatever it is. And, but then we make a few calls and it turns out that it's a condo or a co-op, so that case is dead. You know, and you know, Al and, you know, this organization had a lot to do with that, okay? And just like, let me just tell you, that law is up, again, it's up for renewal, and who knows, maybe amendment, I don't know, you know, I'm not, that's above my pay grade, I'm just a pure subservient. But it's up for renewal in 2018, okay? So, you know, that's a good time to look at the experience with the law, and for us as a community, as a county, to really think about whether, you know, where that, what we want to do moving forward, okay?
Excuse me, Mark, state or federal? It's a state.
No, county law. County law imposed by the federal government.
Right.
I mean, that's accurate, historically accurate. If you look at the, yeah, what I just said, that's it, that's accurate, okay? So it was signed into law by our county, it was compelled into law, okay? Okay. These are just some landmark dates. I don't need to get into that. We don't have the time. You know, I'll just say this about the fair housing law in Westchester, okay? And that's what I highlighted in the pink. The provisions of this law shall be liberally construed, okay? I read all these things very carefully because you know why in New York City, they took that language, that same language, the New York City human rights law, and then they said, okay, the courts aren't liberally construing it, so we're going to do something, we're going to pass another, the city council, we're going to pass another law that says they need to liberally construe it. So then courts started citing that law, the second law, it's called the Restoration Act, and started, you know, kind of adding like a steroid to the New York City human rights law. So, you know, that's the law. So, you know, I'm enforcing the law, I'm going to look at that in my interpretation of the law. So we have a five-member board. They're appointed by the county executive. I can tell you who those people are if you're interested. But I can tell you sometime. They're a five-member board anyway. They're subset of the Human Rights Commission. Okay, like I said, we partner with HUD. Okay, that's an important fact to know about how the agencies run under a program called the Fair Housing Assistance Program. We're only one of three, actually now, three agencies in the state that partners with HUD under this program. It gives us some kind of quality assurance, so to speak, but so that would be us, the state, Rockland, and us. Not even New York City. There's some issue where they couldn't come to agreement with HUD, with the federal government, so they're not even a FAP, called a FAP, F-H-A-P. Okay? And then we go through all this kind of process with HUD. They monitor what we do. Sometimes it's helpful, sometimes it's not, but you know, it does keep us attuned of what the national standard is, okay? And that's all that. Now this is like how the case flows, okay? So we have this intake procedure, that's really not rocket science, that's just what happens, that's how we get our cases, and then we take it and we screen it. You know, some people say, oh, you know, why do you screen it? We have to screen it. I mean, why wouldn't we? We have to screen it, you know, because there's not everything, you can't just throw something up against the wall, okay? It has to have occurred in Westchester. Okay, some people say, oh, you know, they call us from New York City or Connecticut. That's not us. We're Westchester. Okay, so we have to screen things. It has to be within a year. Okay, sometimes it gets tricky because the event might have happened 8 months, and then there was a whole series of events that happened 3 years, 2 years ago or something like that. So we have to look at it before, and then we ask for, and then we just go through this process. We don't have to go through this now, but eventually what happens is we file a verified complaint, which is verified, sworn to by the complainant, the tenant, the resident, okay, in your cases. And, but we don't just file anything. We don't make it onerous, so the burden's really down here, but on the other hand, the burden is down here. So they should be able to get through the door. When I came in, there weren't that many, well, for housing, the complaints were made, but there's more complaints now. More complaints, because I want the standard to be in line with everybody else, the state, the federal standard for filing a fair housing, for filing a complaint. So I keep the burden for that where it lies. If they make a plausible case of discrimination, we're going to file a complaint. Now, if the case will ride through and the chips will fall where they may. So this is a form that we get from HUD. So we get cases from HUD. If there's something happens in Westchester, okay, in one of your buildings, we're going to get it under our contract. And if you happen to come to us, you should look at our contract. You should say, I'd like to see the agreement. It's not, something that's locked up in a vault. It's public. Because you know why? There's things in there that might be relevant to your case. Okay? For your lawyer should look at that. So anyway, we get one of these cases, these screening, one of these forms. We screen it, then we start talking to the people. We investigate what happened. Some cases are not HUD cases, because the category, HUD is under the Fair Housing Act, so there's only a few categories. Westchester County has 15 other categories of, protected classes. Okay, so those would be like non-HUD cases. Okay, I'm gonna zip through here. So we have, a very broad discretion to investigate, and we have very good investigators. One of our investigators was a cop. She's a real, 2 minutes ago, she's 15 years. I'm gonna have to whiz through here. Anyway, look, we investigate, we file a complaint. We have standards for filing a complaint. Let's see. I find probable cause or I don't find probable cause. That's it. There's a standard for finding probable cause. I look at all these different things. I look at federal case law. I look at state case law very closely. If you're a lawyer, if you have a lawyer, I want to see cases. That's compelling to me. I also look at statements from HUD. I'll show you. And then it goes through a hearing. Okay. Now this is tricky. Under our law, you can remove this as a process for a removal to federal and state court. One of the articles I showed you, what the bottom line of the article is that our decision, if you end up going to federal court, our decision can be, you can, just toss it away. Don't worry about it. Yeah? No, for real. It's called preclusion. It has no preclusive effect. It has no preclusive effect. If it goes to a hearing, it may have some more weight, but I found that because I saw this case by Judge Karras, who's our federal court judge up here up in White Plains. I saw this because I saw this case. It's in my article, and he never even mentioned that the case had been with us. So I realized, wait a second, there's got what is the weight of what we do? So that I wrote this article, Professor Carlisle. So we're very, conciliation and mediation. We do everything we can to bring the sides together. I mean, really, I really push that. And I hate to see unreasonableness. I don't know what the next person's going to do, but because it's all gray. This person, there's no moral, certitude in these things, quite frankly. So I'd like to see reasonableness. Okay. Relief and damage, these are things that can happen to you. Unfortunately, for the complainant, you know, we can try and compel the person, like you know, to accept the person into the place, or compel you to let the person, him or her, have the animal, have the dog. Okay. There could be a civil penalty not to exceed $50,000. Let me see. Hold on. I have a review and appeal. They have special topics. Source of income. Handicap. It's a very disability. Reasonable accommodation. Oh, these you need to look at. Okay. These are things. I looked this up the last time I was here. You can get these on Google. The joint statements by the Department of Housing by HUD, okay, on reasonable accommodations and reasonable. I look at that, the staff looks at that. They have scenarios in there. Quite frankly, like I think those scenarios, they're like, to me, they're like the sentencing guidelines. I do criminal law too. I used to do criminal law. They're like the sentencing guidelines. You should use those to see what you need to do to follow. They're like, you know, they're very important. They're very. Yeah, they show a lot. And you know what? You need to be careful because it's a very challenging environment. Fair Housing Act is in June 2015, the Supreme Court came out with a very powerful decision on the Fair Housing Act, underscoring its importance to the nation. In its quest to achieve integration in housing. And there's people out there that you should think about this. They will come at you with, you know, even to tape you. That's not like sinister. That's real evidence. We'll look at that. It's valuable. We have that. We have transcripts of conversations because you know, that's what happens. Sometimes that's the only evidence you can get. So you need to be, you know, you need to do the right thing, you need to follow the law, and you need to realize that people will do everything they can to enforce the law. Okay, thanks. Thanks a lot.
Thank you, Mark. Yes, well, before we take questions, I just wanted to make a couple of observations. What Mark, clearly what I get from looking at his presentation and listening to him, and I'm in dead earnest about this, is that there is a very exhaustive, thorough process by which the Human Rights Commission, under the weight of federal law, operates. But as I was listening to these two attorneys, they were also emphasizing, at least this is my take on it, they were also emphasizing the importance of process and documentation and minutes and bylaws and house rules and the uniform enforcement thereof. No favorites, no exceptions, you play it straight, to use an old-fashioned phrase. And chances are that if you play it straight and you have all of this stuff, all your ducks in line, that if there is a complaint, let me put it this way, the level of agita will likely be significantly reduced. I'm not saying it's going to go away. I'm not saying that a complaint, even under those circumstances, would have merit or would not have merit. You don't know. But you know, if you listen to these three gentlemen very carefully, this is serious stuff. So you know, with that caveat, that sober caveat, it's so important to for all of you, and all of you in this unenviable position of being on the boards of your respective co-ops or condos or presidents. You know, it's a very heavy-duty fiduciary responsibility, and you don't get paid for it. So you've got agita on top of agita, you know. And that was duly noted by our speakers also. So anyway, we'll take it. We're coming on to about 9:05. We'll take questions. I would prefer, with all due respect to the eminent attorney to my left, let's have some questions from a non-legal source first, and then we'll build up to the legal. Anybody in this office, in this room is not an attorney? All right. Any of you have any questions? All right, yes, sir. Oh, by the way, the rules are, stand up, enunciate, tell us if you want to, because, you know, Mark is with the Human Rights Commission, so if you want to identify yourself and your co-op or condo, you're on your own. But anyway, at least articulate the question. Yes, sir.
Yes, it's toward Mr. Lasser. You mentioned that a very good way to get somebody's attention would be towing their car. And I was wondering if that could be, well, not necessarily towing a car, but if somebody isn't paying fees or fines, and they're just letting them amass and just linger on their maintenance month after month for a year or two, could I rescind their parking privileges?
Can you repeat that?
You know what? The person to whom the question is addressed, they will repeat the question.
Okay, thank you.
Okay. So I believe the question is if someone has late fees or fines on their account and they don't pay them and they just let them accumulate over time, would it be okay to tow that person's car for the lack of payment?
To terminate their parking.
Or terminate their parking privileges completely? Okay, so I think I had mentioned this, hopefully everyone heard the questions. Can you rescind someone's parking privileges just completely if they fail to pay their charges? And the issue really turns, and my colleagues can chime in here, but I think it really turns on whether or not the space is deeded. Typically in a co-op it's not deeded, and in some condos the spaces are not deeded either, in which case it's a common area or a common element, and the board has the discretion to control the common areas. So the only sort of caveat is it's sort of things we've been preaching all evening is you need to follow the proper protocol. You need to have a board meeting. You need to decide to do that. One of the things that I neglected to mention is that if you do change the rules, guys, you got to let everyone know, okay? Right? So you got to send out a notice that there was a board meeting on such and such a date. This is what we adopted a resolution, and the resolution was if you have any unpaid charges, you're going to lose your parking privileges, and then it's fair game. I think it's a great way. Like I said, it's a great way to get people's attention. Not always in a good way, but you can cure some problems that way. I mean, I think also. You see it all the time, same thing with pool privileges. You take away someone's parking privilege, you take away their pool privileges, suddenly everyone's coming to get their account current once it starts getting warm. So, other than lawsuits, I think there's a lot of, or there can be some other effective ways to get people to pay their past due fees, including revoking parking privileges.
If there's no need for rebuttal or amplification, Dan?
Yeah, just one thing to keep in mind with revoking parking privileges is, especially in co-ops specifically, a lot of co-ops, the parking is either leased or licensed, and in that case, you can't just, send them a letter, revoke their parking privileges, and give the space to somebody else. There is a process which usually would end up in, serving a termination notice, going to court, and doing some kind of summary proceeding. It doesn't take that long, but you can't, I just want to caution, you have to look at the documents, you have to talk to your attorney, but don't just go there, revoke their parking, give the space to somebody else. That could get you in trouble. It's not quite that simple.
Ron Scher.
Thank you. An excellent presentation by the three of you. And Mark, I've had great success with your commission. But we found some issues involving disabled people asking for parking, not for themselves. They don't even own a car. They want a disabled parking spot for their family members to pick them up. That's one issue. And we have service and therapy pets where we permit them, but we put in provisos with regard to size of pets, size restrictions, and breed restrictions, which I understand is not necessarily permissible. We like to have the 30-30 rule, no bigger than 30 inches, no more than 30 pounds. You can't have a pit bull, you can't have a Rottweiler, you can't have American Staffords, Chows, things like that, dogs that have dangerous and violent propensities. But it's my understanding, if you have a service pet or an emotional therapy pet, we can't even ask you to comply with those rules for violating the fair housing rules. It seems to be a quandary for us that if someone who has a peanut allergy and wants to bring a pony, You know what I'm talking about. People have ponies, people have ostriches, people can bring in any type, and I'm not kidding about this. People can bring in any type, it's not just a dog, they can bring in any type of pet that they claim, that their doctor claims is necessary. I mean, nobody's contesting service pets, seeing eye dogs, hearing ear dogs, or other type of allergy pets. It's my concern with the abuses in the service and therapy pet, because for $75, you can get a therapy pet certificate. Now, we sometimes approve pets that we require people, if you're bringing in a dog, you have to have a dog obedience. You have to pass a dog obedience class to bring the dog in order that it's not excessive barking. Would you opine on that, Mark, as to all the violations I just talked about?
I'll give him the mic, but I was going to say, I know there was a reference to horrible marks before. A Groucho Marxism just came to mind. I think that question was longer than the Gettysburg Address.
Well, it's only 4 score.
So I mean, you know what, if you look at like HUD, they're gonna be like a lot more lenient, you know, it's gotta be, you know, in terms of pets. If you look at the state, there's a case called Nathanson. You guys seen that, Nathanson? Interestingly, this is an interesting inside baseball type thing. Because of that case, Nathanson, HUD will not give an emotional support dog case to the New York State Division of Human Rights. That case, they were the state. It's too little technical, right? But that's in that case, Nathanson, the state. I guess it was the Appellate Division, 2nd Department, the Supreme Court. They were too restrictive toward emotional support dogs, letting the tenant have emotional support dogs. So there's like a divide between HUD and the New York State courts on this issue. Lawyers should know that, or your lawyers should know that. It's interesting. I had some conversations with HUD about that. They don't have anything in writing, but you know, the good bureaucrats they are, as they are down in 26 Federal Plaza in HUD, they won't give a case, an emotional support dog case, animals, to the New York State Division of Human Rights. So in other words, the long and short is the New York State Division of Human Rights is tougher on who gets to keep a dog versus HUD.
It's not barking up the wrong tree.
Right. So on this, you know, I guess we look to see in terms of reasonableness. You know, are they trying to say, you know, oh, there has to be this dog and you can't have that dog, and is it a way to really twist the person's arm to get rid of their dog, which would kind of ruin the whole emotional attachment to it? So if you did that to us, because I like dogs, you know, I'm going to go. I like my drinks and I like my pets. You know what I mean? I'm probably going to be, you know, I'm going to look through that. You know, me and my staff, we're going to look at that. If you're going to do that, play that kind of thing, where it looks like, you know, on the other hand, if you have, like, you look at our reasonable accommodation law, the reasonable accommodation says, like, undue hardship. There's some language like that. So if you have some reasonable standards like that, like, you know, this type of pet, we've had bad experiences with it, and this particular Rottweiler or whatever, I'm not supposed to discriminate, no. But with this particular breed, you know, we've had some instances where they bit some kids on the 3rd floor or something like that. You know, you might be able to make that argument, an undue hardship argument. So, yeah.
Let's say a person has 4 pets, and their 5th pet is their emotional support pet. What do you think about that? Is that reasonable? I don't think
Mark,
that's
you may want to repeat that for those.
So she's saying, like, so let's say you had 4 pets, and my 5th pet is the emotional support dog animal. I don't think that would fly.
Well, it did, and we lost.
Where?
We took it to court, Westchester County.
But we didn't lose through,
HUD says we were not discriminating, but we lost in the court case that she got to keep the 5th.
Which court?
New Rochelle.
New Rochelle City Court?
Yes.
So, you know, that's an interesting thing. I wonder if they even have jurisdiction to talk about, to deal with that issue, because
and it was a pit bull.
It was a pit bull.
And Janet was the president.
Because if you look at Ossining, there's an Ossining, like city court judge, town court judge. He said, I don't have jurisdiction to deal with the discrimination issue, to rule on that. So I wonder who's that, Judge Rice?
Well, I think we have to look more at the attorney that handles these, and I think you'll look for what your desk. We're going to see the initials KC quite a bit, because she's all over the internet, and this is all she does, all the Westchester.
What, dogs?
Yes. Emotional support.
Dogs it's an evolving issue, not service animals. Service animals is pretty clear. That's settled.
You had 4 other pets.
But emotional support dogs, that's a battleground right now with the lawyers on the documentation you need. Okay? On the documentation you need.
I don't want this.
That's a battle, that's a fight.
No, that's okay. Anyone here, and certainly anyone, any member of the CCAC, if you, as you spread the word about this program, if you have, detailed questions, Mark, I'm sure you can email Mark or call them at the Westchester County Department of Human Rights, and I'm sure you will get, a more tailor-made, personal response. I don't want to go into too much of the nitty-gritty here, because we can only deal with generalities, and it's getting a wee bit late in the evening, as we Scots like to say. So we can take a few more questions. Yes, Peg.
Mark, what is being done to cut down on the fraud of emotional animals?
Yes.
Like it was said, you can buy a psychology session for $75 on the internet. You can buy a jacket for the animal.
The question was, what can be done to cut down on the fraud of emotional animals?
And everybody knows all this fraud is out there, but we're restricted by.
Yeah, that's a good question. That's a good question, because that's what I just said. That's where the battleground is in the case law. So if you look at like that case I just said, Nathanson, and there's some other case, I think it's called Overlook Commons, State Supreme Court, Second Department, I think. They are holding pet owners' feet to the fire. So you need your lawyers these guys, to really scrutinize that, and maybe don't settle. Maybe, and this is what we have in our case. We have a case where I had to make the decision to find probable cause, meaning enough to like arrest the person, same thing, probable cause. But it'll go to a hearing, and now our administrative law judge will decide, well, that's baloney, or it's not. He'll look at the evidence, is this really a sham emotional support dog, or, okay? So, but that's where the battleground is.
Right, I have a shareholder who doesn't need the dog to go to work when she goes to work at 9 to 5 and traveling back and forth. She doesn't need the dog when she goes out to dinner on a Friday night or to the bars on Saturday night. But she needs the dog in the morning.
So you might have to give testimony at the hearing, and then the administrative law judge in my court at the commission is going to sort through that, and he's going to have to explain his or her decision, and you might want to take a stand. You see what I'm saying? If I find probable cause, most of the time the case is settled at that point, but you may want to say, you know what, no, we're going to take a stand on this, otherwise there's going to be a dozen other situations like this. We're going to hearing, and we're going to show that this person just whatever,
Next time we get 2 microphones this time. 2 microphones. Yes.
Hi, Stuart Bethard. Been managing for 40 years, so I speak from own experience. What I think is going to happen over the years...
Well, is this a question, Stuart?
It's an observation that's, I think, very relevant. The law is going to fall because people, as we're getting an older population, a lot of single people, households, I think you're going to see more and more pets as companions, and the marketplace is going to demand that the laws become less restrictive, because people will demand to have residences with dogs, pets, to be companions. That goes with a whole other set of problems of how are we going to adapt to living with more animals But I think in the future, this is what's going to happen because we need companion animals. Many people need companion animals. I think, as I said, the marketplace will dictate the law at some point as we go forward.
Actually, it's a good point, Stu Bethal made, because I think recently, to show you how important this is becoming to people, is Assemblywoman Linda Rosenthal from Manhattan had a law passed unanimously, I think, on both the Senate and Assembly to allow people with their dogs to dine al fresco at any eatery in New York City. Now, I love pets, I love dogs, I've had 2 dogs myself. It's almost a religious experience with some of these animals. I kid you not. Those who know me know what I mean when I say religious experience. But having a dog slobbering over, you know, the food at a table with the salt and the pepper and saliva all over the place, and, you know, God only knows what happens after they eat at the table, it just doesn't quite sit with me in terms of, here's where the love of pets or the need for pet companionship overrides a public health concern. The fact that the state's law, I believe, when you mentioned the need for daycare centers, child care centers, trumps, I don't mean to make this political, but, you know, the man is ubiquitous. He just pervades all my dreams and nightmares, and you know. But anyway, the fact that
It's a bridge state.
the fact that a bridge.
It's a bridge state. You use Trump to play bridge.
I don't play bridge. Anyway, but the fact that a child care center has been identified as an overriding social need, but the dangers of, God forbid, a pit bull or a vicious animal somehow is in this gray area still of, you know, it seems to be one of the slides that Dan had up there in terms of the things that should guide you all is, you know, common sense. So it's really a minefield out there. It's really quite perilous, as Marc Fang suggested. Do any of you gentlemen want to?
So I'll keep it brief, but I think one thing that Mark had mentioned is that there's an interactive process. So just because someone says they have a need for a dog doesn't mean you have to roll over and, no pun intended, and allow them to have an accommodation. So there is a fact-finding process. There is the Human Rights Commission. There is a whole process. So as long as you're engaging in a dialogue and not ignoring someone, you're not going to be liable. You're not going to be subject to fine. So you just need to address the issue head on, not ignore it. And then, you know, if someone really wants to have a pet, and they get a doctor, and they hire a lawyer, and they're willing to lie, then they're probably going to get the pet. But if they don't have the doctor, and they don't have the lawyer, and things aren't just right, then you probably have a legitimate basis to deny it. And I think if it goes to the Human Rights Commission, they'll see through it if they don't have all of the right documentation. But if they have the right documentation, you're probably stuck. But it's not like a completely losing cause. So I don't think you should, you know, lead with that attitude that anyone who wants a dog who can buy something on the internet will automatically get it.
We're coming up on 9:30. A couple more questions, or have we all? Yes. Two more questions.
It's not a dog question. It's for Mark. We have a lower and an upper garage with a rather steep incline to get from the lower to the upper. What do we do when a person's physical health deteriorates to the point that he needs an upper garage block, but we don't have one? What's our responsibility?
Mark, you may want to just repeat that.
Repeat
that for those who may not have heard that.
Right, you don't have a spot in the convenient part.
We don't have one in the upper garage.
That's a tough one, you know. So they make a request for the accommodation, request for reasonable accommodation. You're doing what Dan and these guys are saying, which is you're going to have a dialogue with them, maybe have some emails. That's good. You know, we like to see that. Courts like to see that. And then that becomes tricky. You know what I mean? You can't really bump somebody else out.
Yes, you can.
You can?
Yes,
okay, I
you
know that.
That's
But
what happens.
what if all those people have disability too?
look, if everybody in the upper garage has a disability, then I suppose there's probably, if everybody in the upper garage has a disability, then I suppose there's probably nothing to do. But if there's a spot in the upper garage where for somebody who doesn't have a disability has a spot in the upper garage, and you have somebody who has a spot in the lower garage, but they need one in the upper garage because they have a disability, then assuming that they're not deeded spots, then you can require them to change. That's what you have to do. It's the standard, I mean, and this goes to the pets, this goes to anything, the standard is reasonable, and you have to be reasonable, and the accommodation request has to be reasonable. That doesn't mean that it's not going to impact another shareholder. It might impact another shareholder, but the accommodation request still, in that particular circumstance, that's probably a reasonable accommodation. That somebody who's not handicapped and can walk up the incline, okay, so now they can't have the convenient parking spot. It's that's what that law is guided towards.
50 spots, who do you ask?
What?
Some people, we have 50 spots upstairs. Who do you ask? And some people.
That's why you get paid the big bucks. That's why you get paid the big bucks. You have to look at the different, and I ingest, but you have to look at the layout, you have to look at the garage. I mean, there could be a number of factors. There might be one spot in the upper garage that's much more convenient than the other, so maybe it's that person that has to suffer. Maybe it's, maybe you look at, who the most recent person to go up there was. I mean, there could be a number of different, criteria that you use to evaluate it, but, that.
On that point, before I give it over to Mark, on that point, could a co-op just simply notify the parking space owners on the lower level or the upper level and say, we have this situation and appear to the better angels of their nature and their sense of noblesse oblige and say, we have this situation, would anybody be interested in switching so that this handicapped person can have...
You know what they should do? They should have, which is what Dan's getting to say, you should probably have some kind of policy, you know what I mean, that gives you the leeway to do something like that, right? You see what I'm saying?
Yeah, I mean, I have...
Saying, no, first in, first to get out, if in the event of.
We have done that. We have asked people if there's anybody who wanted to voluntarily give up a spot.
Exactly.
And sometimes we've even given them some type of incentive to give that up, such as like a meal, give them a card to do it. But in the end, if there is a handicapped person who wants to move upstairs, and there are people upstairs who are not handicapped, they're going to lose that spot unless you can find an alternate spot upstairs. Like you may be able to renumber, to restripe, to find another spot up there. I had a building in the city
We had that up here where it went before Mark. And
we had a building that changed their entire upstairs to valet parking where it didn't matter any longer. That if it wasn't, they would be able to give it out, and if you were handicapped, everybody was able to give it to the caregiver there.
All right, so
If you
Dan
give it an incentive,
has...
we'll get you county money too. We'll compensate you with county money. No.
Dan has a few more remarks on this, and we have one more question to go.
I had a building with a similar situation as Ron, that it went before there was a complaint, it went before the Human Rights Commission, and ultimately we went through the whole parking, map, and we asked people, we had to go through that, we had to ask people if they'd be willing to switch, and ultimately we couldn't, and we had to identify a specific spot, so we ended up just having to force somebody, but it does happen.
Hillary, you're the last question. Stand, please, young lady, stand.
Hillary Shepard, Surf Pro Scarsdale, and we deal with hoarding. We do dirty jobs. So you can back out a second. So we've been brought in cases, we will bury them in paperwork. I mean, we try not to kill trees and growing greens all our time. But I will print if I have to. In the hoarding situation, and Dan, you guys need to maybe research this, and this is something for Mark as well. Hoarding, by the way, it has an A in it. H-O-R-A. H-O-A-R-T.
Okay.
But no worries. My husband did that on our PowerPoint. I'm like, excuse me? So
It's typing fast.
the upshot is that hoarding is OCD. It has been psychiatrically diagnosed as obsessive compulsive
Oh,
disorder.
absolutely. That was why I was saying that you can't just fine with it. It's something that has to be dealt with on another level.
Don't get sued, is what I'm saying. And
but it's a fire hazard, it's unsafe.
Right, exactly, it's,
It affects
I understand
most
that don't get sued, but on the other hand, and it is a serious condition, it's not, and I'm not saying, that was kind of my point, is don't take it lightly, but it's also something that, as a board, if it's going on, you can't let it go. That is a, that is a quality of life situation that, that does need to be addressed, and we've dealt with that in condominiums. We've had condominiums where we've brought actions to deal with that, and it's unfortunate, and it's not the first thing we do. There's other things you can do there to try to get other people or agencies involved if you have to, but a lot of times that doesn't work. And we had a situation where we brought the action, we resolved it, they got it cleaned up, and within months, it was right back to how it was. And it just, I mean, yeah, exactly.
All right, a couple of announcements before, anyway, a round of applause for our speakers.